Hi, this is Patrick Virgadamo. I'm Senior Attorney at the Louisiana Legislative Auditor's Office, and this is Module 4, which will cover FEMA contract procurement, federal contract procurement for political subdivisions. So we've talked previously in previous models on contracts in general, Module 1, public bid law in Module 2, the Louisiana Procurement Code in Module 3. And in Module 4, we're going to talk about federal procurement, which is important for those political subdivisions which are seeking reimbursement from FEMA under the Public Assistance Program or other federal grant programs, and the rules that have to be complied with in addition to the state procurement laws that we've already discussed. The key thing to understand under federal law is that it focuses on reimbursement. And so the way this programs are set up is we have statutes, regulations, policies, and disaster-specific guidance, all of which work together to give us rules that have to be followed when seeking reimbursement for purchases following a disaster. First thing to understand is the Stafford Act, the federal law, which can be found in 42 USC 5121 at SEC. This law authorizes the Public Assistance Program, which allows for the federal government to provide reimbursement to state and local entities for the costs incurred in recovering from a disaster. It's important to understand this is what gives FEMA its authority to provide assistance. It defines basic program criteria and eligibility and authorizes FEMA to promulgate and publish regulations. It's important to know the provisions of the statute cannot be changed by FEMA. Only Congress through congressional act can change those provisions. Code of Federal Regulations in Title 44 basically provide the rules to implement the Stafford Act. It is based on interpretation of the statute, which is done by FEMA through rulemaking, and it's a formal publication and comment process, which is required in doing this promulgation process. It's important to note these rules, once fully promulgated, have the same effect as law, and they can be changed by FEMA by additional rulemaking. Public Assistance Program can be found in 44 CFR Part 206. Disaster-specific guidance, which is something that falls below that, is issued directly by FEMA, and it applies the laws and regulations to specific disasters, such as in the cases of Hurricane Katrina, Laura, Ida. All of those specific disasters have specific guidance which tries to take the law and the rules and apply them to how FEMA is going to expect political subdivisions and states to operate in getting disaster assistance under public assistance for those specific disasters. You cannot use that guidance outside of the disaster for which it's issued. It's in its name, disaster specific. So you'll note when looking at disaster specific guidance, say from Hurricanes Katrina to Hurricanes Rita, that guidance changed as FEMA recognized issues in dealing with one disaster. They updated their guidance for the other subsequent disasters. The FEMA website is where you'll find this disaster specific guidance. Now, policies, there are disaster specific policies that FEMA may also promulgate. The application of those policies are going to be specific to that disaster. Examples, the Public Assistance Guide, where FEMA has put out policies on how they're going to kind of expect and interpret certain requirements. You also have the Public Assistance Public Digest, and those can all be found on the FEMA website. Now, as of 2016, you have FEMA has the Public Assistance Program and Policy Guide, which you'll also sometimes heard referred to as the Papa G. The key thing there is this is a kind of an amalgamation and condensing of all these things in one place to help entities and states and local entities who are trying to seek reimbursement under public assistance. You can find that at FEMA's website under assistance/public. Now, federal standards, the procurement standards for disasters that happened on or after December 26, 2014 are now found in a completely different section of the federal rules in 2 CFR Part 200. And so that will apply to those disasters. 44 CFR Part 13, even though it is now repealed, is still effective for all those disasters that occurred before December 26, 2014. So, for example, Hurricane Katrina, Rita, Gustav, Ike, all of those that occurred before 2014, which necessarily haven't closed out, are going to still follow and refer to the rules under 44 CFR Part 13. So as we go through this, we'll talk about, and the slides will kind of show you, depending on which standards you're having to apply to, depending on when your disaster occurred, they're not completely different, but they are more condensed and more, the requirements are slightly different under 2 CFR, in the sense, in general, the requirements are similar, but the wording is different. So, for example, in 44 CFR 13.36, it basically, the rule provides that states, and this is the state itself, when procuring property and services under the grant, will follow their normal rules. All other grantees and subgrantees, so this includes all political subdivisions that are not state entity, have to follow all the other requirements that were in B through I of that section. It's important to note under 2 CFR 200.317, it makes it clear that the state has to just follow its own procurement rules, and except for certain things that have to do with affirmative action and things of those sorts that are applicable to all entities that receive federal funds. All other non-federal entities, including subrecipient state, have to follow all the specific rules under 2 CFR sections 203.318 to 3.326. And so it's important to note, depending on what your entity is, if you're a state entity, you follow your normal rules, procurement code. If you are an entity who is a political subdivision, you not only have to follow your state and local rules, you have to also follow specific federal rules. And we're going to go through those in general, of those things you need to be mindful of. Now, under federal standards, it's important to note the federal government expects that all purchases be done through a competitive method. 44 CFR 13.36 and 2 CFR 200.319 make it clear that in order to receive reimbursement, the expenditure, unless an exception applies, has to be through a competitive method. This is usually not a problem, because if you're following the state laws under public bid law, its processes provide for competition, that bidding process, those quotes. And so in theory, if you follow both the state rules and the federal, in most cases, you're going to be good by following one or the other. By following one, you're following the other. However, we're going to try to point out where there's some cases where one may be more stricter. And in all cases, because you have to comply with all of these rules, the stricter one you'll have to comply with. The federal government expects full and open competition. They want to make sure that geographical preferences aren't favored. They don't want you limiting your submission of bids or your quotes to just a specific local vendors, except in the cases of architects and engineering services, because in some of those cases, the licensing and building codes may necessitate using a local preference. Written selection procedures must be done to identify that you're going to fulfill all of these requirements. So it's not just fly by your seat of the pants. You really should have a plan and written procedures in place to show and document how you're complying with all these federal procurement requirements, so that when you go to seek reimbursement later, you don't jeopardize your ability to potentially get reimbursed by the federal government. One thing that the federal government wants is all pre-qualified lists should be current. So the idea is that if you're going to be doing emergency procurement where you may not have to be as competitive because debris removal, they want you to make sure that if you're going to have a preset list of people you're going to reach out for quotes, you're keeping it current, so that when it comes time in the heat of the post disaster, you already have a game plan in place. And so they want to make sure you have enough current and accurate information to get competitive and open competition on your quotes and solicitations. Now, the thresholds under 44 CFR 13.36 for all those local governments, you have small purchase procedures, and then which are anything that are less than 100,000, and then you have price quotes from which anything that's less than 100,000, you're required to get price quotes from an adequate number of qualified sources. So this is going to be similar to your procedures under public bid law, for that 30 to 60 where you're getting at least 3 quotes. The idea is you're ensuring you're getting some competition so that the amount you ultimately spend is competitive. It's important to note you need to document that you obtain these quotes and that you have enough quotes so that when it's asked to explain why did you pay this to this entity for something less than 100,000, you have that documentation so that you don't jeopardize your reimbursement. It is important to note this conflicts with the state small purchase procedures and the public bid law materials and supplies requirements, because as Angela talked about in module 2, any purchases of materials and supplies that are 30,000 but not more than 60 require 3 quotes. Anything over 60 requires you to bid it out. So even though the federal government allows you to just get quotes up to less than 100,000, because you also have to comply with state public bid law, anything over 60, unless an exception applies under state public bid law, has to be bid out. And so the stricter law in that case would be the state law, which you have to comply with in addition to the federal provisions. Now, under 2 CFR, it has a much more diverse breakdown of requirements. First, you have what they call micro purchases, which are things that are $10,000 or less. And so unless in 44 and 48 CFR 2.101, there's a specific thing that says you have to do this amount for this type of purchase, generally speaking, anything that's 10,000 or under just requires you to get some distribution among qualified suppliers. You can award this without soliciting competitive quotes if the price is reasonable. This is going to be similar to under the public bid law for those things under 30, which basically say the law doesn't specify any specific requirements, but you do need to remember that under state law, Article 7, Section 14 of the Constitution does require you not to donate public funds. So you still have an obligation to make sure under state law and as noted here under federal law that all your purchases are reasonable. And this is important to the feds because if it's not reasonable, they're not going to reimburse you. Again, you should note there is potential conflict here for public bid law and materials and supplies in the sense that the federal government and the state are not necessarily requiring the same specific requirements. However, you just need to make sure you can comply with both. And in where one case is stricter than the other, you're doing the stricter requirement, even if it's not required under the other. Small purchases are now less than 250,000, or what is at that time of the purchase, the current simplified acquisition threshold as defined in 48 CFR 2.101. Again, this provision, similar to the small purchases executive orders that the governor issues for state agencies under the procurement code, may specify specific rules for specific types of procurement, like feed, agricultural expenditures, things of those sorts that are very particular in nature. However, generally speaking, for small purchase procedures, you have to get quotes from an adequate number and document those. It is going to be much stricter requirements than it would be for those micro purchases. It is important to note, again, state public bid law requires anything over 60,000 to be bid out. So even though the federal law may still put this as a small purchase, because you're also subject to the public bid law, you have to comply with its requirements for those things over 60. Now, sealed bids is the first method that's authorized under the federal procurement rules as a means of actually bidding out a contract. There are formal advertising requirements, and these are the citations you'll find for it under 44 CFR 13.36D and 2 CFR 200.320B1. It is the preferred method for construction contracts. The requirements can be found in the CFR because you always want to make sure you have the most up-to-date for when you're actually doing the procurement. It is important to note this is essentially the same method that's required under the public bid law for public works, because those construction contracts require that advertising, receiving formal bids back that are responsive, and then awarding it to the lowest bidder. If you do not use this, the federal government requires you to document what the applicable exception was that allowed you not to use sealed bidding. Again, noting it is the preferred method for construction contracts. Now, non-competitive proposals, there are some, just as the public bid law provides some exceptions for under state law to not have to bid out something or be competitive. The federal government also has certain non-competitive authorizations. Sole source, this is one of the ones, it's important to note, under the public bid law, there is no such thing as sole source. It requires you to go through the exercise that when it says you need to bid something out and there's not a specific exception, you have to at least solicit. So if you only get one response, you get one response, but you can't just take the word of a vendor saying, well, we're the only sole source. It is difficult to prove. And even under the state procurement code requirements for state agencies, it is not enough that it's only made by one entity. It's, do you have multiple vendors that provide access? For example, Apple is the only one who makes Apple computers, but you can buy Apple computers from Amazon, Best Buy, Costco, and several other vendors out there that will sell you an Apple computer. So there is no such thing as a sole source for Apple computers. You also, in some cases, have to, especially in the public bid law, consider similar items. You can't just go by a brand name, so that just because so-and-so is the only one who makes this specific brand, if someone makes a similar item under a different brand, you have to at least consider that in being competitive and bidding it out. Public urgency or situations, basically your emergencies where because you don't have time to go through the process. It's the same thing as the emergency and extreme emergency procedures for public bid law. Basically, you need to document those things and show how you couldn't wait to go through the formal process because of some public urgency. There also may be situations where the federal awarding agency may specifically authorize non-competitive procurement. It's important to note and have that documented and not just relying on you believe they'll allow it, because at the end of the day, the goal is to get reimbursed. After solicitation of number of sources, competition is adequate. Essentially, the federal government says if you go through the process, you advertise again, and you still only get, say, one person responsive to your construction contract, then you're documenting and showing, well, we tried to solicit, we weren't able to get them, and so we're able to now utilize the one response we got. And so that essentially says if you try and document that you did everything you were supposed to do to solicit competition, but just could not get it, there is an exception under the federal rules for that. Remember, as a political subdivision, you still have to follow the public bid law. Public bid law basically says, here's the process to follow. By following it, you satisfy that requirement under state law. Competitive proposals, these are going to be the things where you're not necessarily bidding it out and soliciting sealed bids, but could be situations where it's a qualified based method. So for architectural engineering, as Angela would have talked about in module 2, under state law, we don't want you necessarily considering price as the primary means for selecting someone to design a building. We want to make sure that they actually have the qualifications to do it and then negotiate a price. So an RFQ, a request for qualifications, are often the method that are used for those types of contracts. And the federal law has a similar provisions where you evaluate the qualifications of that person and then pick that most qualified and negotiate a price. Obviously, it's subject to negotiation of fair and reasonable compensation. Essentially, once you determine who's most qualified, if you can't negotiate a price with them, you next go to the next most qualified and continue to negotiate a fair and reasonable compensation based on that qualification-based selection. Local entities have to follow the stricter law because you'll note under state law, it just says you can't consider price in selection as the primary thing for selection, but it doesn't specify a specific procedure. There is specific procedures for state agencies for contracts over $1 million or more, but locals in selecting their architect and engineer, there are not particular requirements for the process for selecting one. They can simply negotiate with their person of choice. That is different when you're looking for federal reimbursement because it may require you to use an RFQ process to select them when you want reimbursement under the federal law. That would be a stricter requirement than what's required for the political subdivision under state law. Piggybacking, it's important to note, revised statute 38 321.1 authorizes public entities to purchase off contracts that are previously bid by other Louisiana public entities. Piggybacking, you have to have a previously bid contract by a Louisiana public entity. It can't, under the statutory method, cannot be more than a year from the bid opening, and has to have the same services and supplies at the same or lower price, not to exceed twice the amount of deliverables that were originally purchased. This is important because you have a big parish, you have a small parish who bids out, say, purchasing 2 vehicles. It's going to be different than a big parish who's looking to buy, say, 20 times as many, because they probably would have gotten a volume discount on that under bidding, a formal competition. So the law basically says you can only buy up to 2 times as much of the contract you're piggybacking off of. It's subject to the written consent of all parties, and the public entity that originally bid has to certify in writing compliance with the bid law. This is usually simply done by an email to the one who wants to piggyback saying, we bid this out. This is when we opened the bids, so you have this in your files. The local services law authorizes, it's a separate one, and this is the more older method that the AG had historically said could be used, which would allow parishes, municipalities, and political subdivisions to purchase off existing viable contracts that have previously been bid by another Louisiana political subdivision. It's important to note, in order to utilizing existing contract under the local services law, the steps, while similar to the statutory method, are different. The contract has to have been bid in compliance with the public bid law, so that is similar. It still has to be active, fresh, or viable. This is different than the statutory method, which just needed to be within a year of the bid opening. And what the AG has said by being viable, if the entity who originally bid out a contract, selected somebody, and got the item that they bid out for, that contract's done. It's no longer viable. If they haven't accepted delivery, or if it's a requirements contract where it continues in effect for a certain period of time, then it's still considered viable and you can use that contract. You still, again, have to get that written consent and approval, and they have to agree to provide the same product at the same or lower price from the vendor. It's important to note that FEMA considers piggybacking non-competitive, which means unless you can show that you meet the exceptions to be non-competitive, it may not be allowable when seeking federal reimbursement or using grant funds. A public entity has to do a cost analysis to receive reimbursement from FEMA, and they're going to have to show how using this was reasonable, and that should have been allowable as a non-competitive process. It's important to note FEMA will not reimburse unreasonable costs associated with piggybacking. So it is one of those ones that sometimes it may be better to go ahead and do the process yourself than just trying to piggyback. This is different than if you're on the front end, you and say 2 parishes get together and bid it out together. That is not piggybacking. That is cooperatively bidding it out together from the get-go. And that would be competitive. 44 CFR 13.36 has some other issues that are of note. Affirmative action, which is required under 2 CFR 200.321, because any federal contracts and federal grants, and there are requirements that be complied with. Grantees have to take necessary steps that minority firms, women's business enterprises, and labor surplus area firms are used when possible. To see if cost and price are important, you must make sure you perform a cost or price analysis in connection with every procurement action. So this is that documentation requirement that includes any contract modifications that exceed the simplified acquired threshold. So if you have those change orders, which Angela would have talked about in module 2, that suddenly take you above an amount where you would have had to bid it out formally, you need to have some kind of analysis that shows the reasonableness of all those, so that the question becomes, why didn't you bid it out in the first place? And so you want to be prepared for that to get that reimbursement from the feds. Now, the federal law provides for certain acceptable contract types. These types will always be considered acceptable as a type of contract. Lump sum, this is the simplest type of contract where basically you have a clearly defined scope. I will pay you X to do Y. You do Y, I pay you X, and that's it. There's no other qualifications in that. Lump sum work is going to be an acceptable type. Unit price. So as under the for public works, you may have situations where you're not necessarily paying a total price, you're paying for an item by item basis for those units. So like under requirements contract for materials, you may not know how much fuel you're going to buy, but you know this is how much I'm going to pay for all the fuel I need during that period. And so a unit price is basically, it may not have a specifically defined price, but you do have a specifically defined price for the item. And so depending on how many items you end up using or buying, that's how much you know you're going to pay no matter what. Cost plus a fixed fee. So lump sum or unit prices with a fixed contractor fee can be allowable, so that I'm going to charge you X and then I'm going to charge you a cost of, say, $2,000 for this fee. That can be allowable because it's all up front. Time and materials can be also considered acceptable, but you have to have monitoring. It's important because you have to also have a cost ceiling, because if you don't have these things, you can get into situations where the amounts spent are not reasonable. They can only be for a limited period of time. Previously, this was no more than 70 hours, but now it's a reasonable time for the work, and it has to be immediately. The clearest example of this is debris removal. The key thing is, in doing this, you need to make sure you're monitoring. For example, FEMA has called out public entities in the past by not monitoring. You need to know if you're paying by truckload for the debris that's being brought and hauled. You need someone who's actually monitoring to make sure you're actually paying for a full truck. If you're paying for a truck, that the truck is actually full, not 2/3 or half, so that you actually are monitoring that time and materials to ensure that you're actually getting what you're paying for. Cost ceiling, so that if all thing goes wrong, you have a not to exceed, so that even if something fails in the monitoring, you're limiting your total exposure. And so you have to have some kind of cost ceiling. And then again, it's for a limited period of time. Just in that few hours or few days after the storm where you need someone to go in, get all the debris off the road so that you can get everybody in and start rebuilding, that's going to be those type of situations where time and materials are used. It's important to note there are specifically contract types that are deemed unacceptable, and if you have these, will be disqualified from reimbursement by the feds. Cost plus a percentage of the cost. What this means is you can't agree to a contract which says, I'm going to pay you, contractor, this amount and then a percentage of that total cost to you as a fee. The reason for this is there's no incentive for the vendor or contractor to keep costs reasonable, because the more the costs go up, the more they get, because it's a percentage. And so because it's rife and for potential of abuse and problems, the feds have basically said you can't do that. Contingency. More than one political subdivision has gotten in the problem of, because federal contracts are reimbursements, you cannot have language that says we will pay you if and only if we are reimbursed by the federal government, because then it doesn't look like you've actually reimbursed. You've never obligated yourself to spend those monies. And so the federal government's just like, we're not going to do that. You have to actually incur costs that are reasonable for us to reimburse those under the program. Additional information for this can be found under our legal FAQs, which are found on our website. If you have questions from this, please give myself or Angela a call. If we don't have the answer for you on these things, we can definitely direct you to those who likely have that information. Specifically, for instance, the Governor's Office of Homeland Security and Emergency Preparedness, GOSEP, they deal with federal government and federal procurement rules all the time. And so they are a great resource. We're always happy to help you, put you in touch with them if need be. But if we can be of any assistance, please let us know. Thank you.